All right, so let's just begin with the Fifth Amendment. The Fifth Amendment of the U.S. Constitution was put into play 1791. In 1791, this amendment became law. And I'm just going to read the first sentence of the Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or an indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. So there is a nullifying clause there. Nobody can be held to a felony charge without a presentment or an indictment of the grand jury, except if you're a part of the land or naval forces or the militia when you're actually in war, during service for a time of war. Then you don't get a grand jury indictment. But every person has a right to a grand jury indictment or presentment before a felony can be put upon them. That comes from the Fifth Amendment of the U.S. Constitution. It's also a part of the Colorado law, which, if I have time, I'll read it later. But so far, we're looking at an originalist court. You have 6 of the 9 Supreme Court justices. They say they're conservative, right? To conserve the Constitution, to rescue the Constitution, to save the Constitution. And then not only are they conservative, 4 of them are originalists. So they're saying not only do we look at the words of the Constitution and interpret them exactly as the words say, if we want to find out, clarify the meaning of those words, then we go to the original authors and we listen to what the original authors have to say. That's Clarence Thomas, that's Amy Coney Barrett, that's Neil Gorsuch, and then that's Alito. Samuel J. Alito. I think it's Sam Alito. So then we have the hierarchy of laws. You got the U.S. Constitution as the supreme law of the land, right? Constitutional law trumps statutes and it trumps case law. Probably also trumps like ethics and grammar and margins and a bunch of other stuff. Constitutional fidelity trumps practicality. This is old-fashioned. The grand jury has been in America for the past 859 years. In America specifically since 1624-25 in Massachusetts. But in the Anglo-American history, we've had it for 859 years since the assize of Clarendon. So it goes back to the Magna Carta. Even before the Magna Carta, Black's Commentaries has it. I want to say Hale and Koch. One of those 2 guys had mentioned, I'm not for sure about the other. And then 34 of 35 of the U.S. states in 1871 had great provisions. 8 of the 50s today have great jury provisions. So jury legal history is still with us today. And then the grand jury history has been going strong since the 1100s, 1200s, 1300s, on and on and on, up until just 2 years ago, you had Donald Trump, who got indicted by 4 grand juries. He had 4 indictments in 2023. Now, I'd stop this off at Hurtado. So Hurtado, there's some people might say, well, what about Hurtado v. California? Oh, yeah, the Waits Court. You want to talk about the Waits Court, huh? So the Waits Court, there's a bunch of problems with the Waits Court. First of all, they rely on common law. Common law, the trial by blood, the ordeal by blood. So in order to find out if a person had killed another person, they would take the person. This is during the Middle Ages, aka the Dark Ages, because the times were just so dreary. Let's just forget about those times, right? Before the Renaissance, before the Enlightenment, you had the Dark Ages. They were using the common law. The ordeal by blood was they would take the accused person. I know you killed that person. They would take that accused person. All right, if you didn't kill the person, then go touch that dead body. And then the accused would touch the dead body of, whoever killed them or whatever. Maybe they killed him, maybe they didn't, but they're touching this corpse. And if the corpse bleeds, or if the corpse moves somehow, just touch the dead body. And if there's blood that comes out of its eyes, out of its nose, out of where you touched, and if somehow the corpse moves, that means the soul, the spirit of the corpse was still in there, and they wanted revenge. Guilty. I think you're the one that killed him. You touched that corpse. When you touched it, you moved it slightly, and I'm not going to see that you had moved it. I'm going to say that it was the spirit of the corpse wanting revenge against you. Also, ordeal by the cross, where you had to hold up your arms. Ordeal by boiling water, where you'd have to pull something out of boiling water, and then it was how it healed. And then the ordeal by cold water, you throw somebody into the river, and if the river baptizes you, it accepts you. But if you float, you're a witch. I don't know. The common law is pretty dumb. Plus, King Henry VIII beheaded 2 queens because he wanted to have sexual relations with his mistress. So because King Henry VIII wanted to have sex with his Marilyn Monroe, or because he wanted to have sex with his Monica Lewinsky, he come up with some trumped up charges, got 2 of his queen headed. This is where we're going to get our common law from? We're going to get our common law from Henry VIII, huh? Who was also obese, and he just didn't murder his queens, he murdered a bunch of people. A bunch of his political opponents. Harlan dissented. The famous Harlan, the same guy who also dissented with Plessy v. Ferguson. So Hurtado v. California is 1884. This is before the Incorporation Doctrine. 41 years before the Incorporation Doctrine began, which began on 1925 with the Gitlow, was it v. New York Gitlow case. England doesn't even use common law today. Hurtado was also accused of murder. And so, part of me thinks that the Supreme Court justice is considering justice. Should we give this murderer a grand jury indictment? So this happened in 1884. They initially rejected that the Due Process Clause had applied to the state governments in Hurtado v. California. The Waite Court was a terrible court. They were the same ones who, did the Crookshank cases. The Waite Court had U.S. v. Reese, Minor versus Happersett. They had U.S. v. Crookshank, which was about the Colfax Massacre. Elk v. Wilkins, Pace v. Alabama, the civil rights cases. Presser v. Illinois. Don't even talk to me about no Waite Court. Back in 1884, you're trying to tell me this court back in 1884 knew what the hell was going on? So, Hurtado v. California, 1884, it actually says something more specific. So whereas it says that you can skip over the grand jury, so you have an exception. And in fact, I'm like just putting the goddamn, opposition. Here's, if I was opposing myself, I say you have a right to a grand jury indictment. Now, you would say, if you were opposed, or I would say, the opposition would say, no, you don't have a right to a grand jury indictment because of the Hurtado case. Hurtado v. California, 1884, says that the grand jury is not incorporated to the states. It's not incorporated to the states. Well, Hurtado v. California says something very specific. It says that, yeah, you can skip over the grand jury, but you can only skip over the grand jury as long as you qualify 4 steps. You got to have a magistrate. You got to, listen to the damn case. You got to have a preliminary hearing. You got to have a preliminary hearing where the prosecution introduces evidence and witnesses, and the defense can't introduce anything, but the defense can cross-examine. They can cross-examine the other side. So there's many reasons for that. You can kind of see if, as a defense, just to see what case they got, what evidence that they have. But at the very least, you got to have a probable cause determination. The judge, the court, has to have a probable cause determination. Is there probable cause that a felony has happened? So they're trying to say practicality, we can't just do a grand jury all the time. So when it comes to Hurtado, Hurtado says you have to have a preliminary hearing. You got to have a preliminary hearing. And then when you finally issue the charges have to be in the form of an indictment. In Washington, they have the certificate of probable cause. So after you go through a preliminary hearing, you got to end up with a certificate of probable cause. So even if you were to say, well, Hurtado v. California says that you don't have to have a grand jury, well, you got to have a preliminary hearing. And guess what Colorado didn't do? Guess what Ann E. Kelly didn't do? She didn't have a preliminary hearing. She didn't have an evidentiary hearing. She didn't have a grand jury indictment, but there was no probable cause determination. Without probable cause, you don't have due process. You got to have probable cause before you can have due process. There's some other cases that says that there is a malicious prosecution. Without probable cause, that's a malicious prosecution. Without probable cause, I mean, that's the whole name of the game. You went ahead and forego this big, clunky grand jury. You didn't want to get 12 people in and get 9 of the grand jurors to say that there's probably a crime. There's probably some probable cause going on here. So you skipped, in lieu of the grand jury, you're supposed to do a preliminary hearing. Colorado law also protects a preliminary hearing. They got some exceptions, but they protect a preliminary hearing. And I want to say, I don't know the exact words to it. I want to say the numbers. I wrote the numbers down actually here. So let's take a look at where in Colorado do they say the Grand Remonstrance had the grand jury? The Grand Remonstrance had the grand jury. What else had the grand jury? Edward Coke. That's who it was. Edward Coke talks about the grand jury. Charles II. He tried to indict his enemies, but the grand jury refused to do so. But then he's going to throw one of them into the Tower of London. The first Earl of Shaftesbury, Anthony Ashley Cooper, and Stephen College. So grand juries protected 2 of the king's enemies. Since the procedure was being abused to go after political and private persons, there was a 1692 statute for William and Mary C-18 was passed, which required informations of private persons to be approved by the court. So you can't just have some asshole lie and then have some other asshole kidnap a body and then have some other asshole say, yeah, I'd like to abuse that body. And that's due process. Due process isn't just having perfunctory steps. So even if they just said, well, we had a disposition hearing and we had this other hearing here, we had a couple hearings. It's not just jumping through a couple fucking steps so you can hurry up along with your fucking conviction. The whole point of having the procedure, the rules of evidence and rules of procedure is to get to the damn truth. You can't have objective justice unless you have objective truth. So even though England is going to get rid of the grand jury in 1933, from 1166 to 1933, England had the common law grand jury. And so when the colonization of America happened from 1600s to 1700s, we brought the grand jury here. In fact, the U.S. Revolution, the American Revolution, we weren't talking about brand new freedoms that nobody had talked about. We were saying since we were British subjects, we were entitled to the rights of the British. But the British says, no, you're colonists, so you don't get those rights. You don't get those freedoms that we here in England and the motherland get to have. Since you're the subjects, you don't get any of the damn rights. And so the American Revolution was actually very much a defense of the legal rights that the Americans felt they had under the English law. We are Englishmen. We're Englishmen, so therefore we have these rights. Well, they're not giving us the rights. So then we got to create an America. Now we got a brand new America. These are the rights that all Americans have. So I want to keep going on with the history of the grand jury because it's fascinating to me, but I want to get to the laws of Colorado. So what were the laws of Colorado? You have Rule 7 of Colorado Criminal Procedure. Rule 7 of Colorado Criminal Procedure says that you got to have a preliminary hearing. Also, CRS 165208 and 165301. So you have 2 CRS 165208, 165301. Both of them say you got to have a preliminary hearing. Rule 7 of Colorado Criminal Procedure says that you got to have a grand hearing. So what does all that mean? That means this case is right. Before Griswold v. Connecticut, 1965 became law, you had 2 previous cases that was headed to the Supreme Court. Tileston v. Ullman and Poe v. Ullman. So 1943, Tileston v. Ullman, and 1961, Poe v. Ullman. U-A-A-M-A-N. Unfortunately, they said that they lacked standing. You know, there was like some, sort of administrative error or something, but there wasn't a prosecution without the damn grand jury indictment. They lacked standing and the case wasn't right. in my case, the case is ripe. The case is ripe. Now, for the kicker, I think this is the best argument, frankly. Not only do the freedoms that we have mean that we have the freedoms, right? We got the First Amendment, Second Amendment. If I'm just, Joe Blow Americans, number 8 says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Well, then I think, you're not allowed to do cruel and unusual punishments. Well, I want to just take poop and smear. I just want to take the guy's face and just smear his face in a bunch of pig shit. That's cruel and unusual, Can't you just, take the guy and put him behind bars? Isn't there something else you could do? And then you can't have excessive bail nor excessive fines. Well, he gave me the stink eye, and nobody gives John Masters the stink eye. Since that guy gave me the stink eye, I'm going to throw him in jail, and I'm going to give him $1 million bail, and then I'm going to fine him $2 million. Nobody gives John Masters the stink eye. Nobody. So the kicker is this. We've had this incorporation process that's happened from 1925 until today. So actually, this is the 100-year anniversary. So congratulations, America. We started to incorporate the freedoms of the federal Constitution to the states for 100 years now. So that's exciting. The Gitlow v. New York case has been good for 100 years. So let's have a party. Ha! Yay! Whippity skippity doodah day, huh? That is actually exciting. 100 years since Gitlow v. New York. So you had Barron v. Baltimore, which said that it didn't apply to the states. So for about 100 years, it wasn't applying to the states. So America was 1776, but we didn't get our freedoms until 1925. And actually, Gitlow lost that case. But in Gitlow, they did set the principle that said, of course, we believe that the first 8 amendments are incorporated to the states. Of course, we believe that. So even though they ruled against Gitlow, they ultimately set a rule that says that we actually do have those freedoms and that they can be incorporated to the states. It's not just in federal courts against federal agents, but we actually have our freedoms and our rights from the Bill of Rights in state courts against state officials as well. So that's exciting stuff. When it comes to the incorporation process, you got the first 8 amendments, right? We're going to put Amendment 9 and Amendment 10 to the side. Let's just look at the first 8 amendments. We're also skipping habeas corpus, and we're skipping some of the rights, the women's right to vote. But we're looking at just the first 8 amendments of the Constitution. Well, by my calculations, there's 32 individual freedoms in the first 8 amendments. There's 32 individual freedoms. And Grok said there was over 80%. Since you only had 3, 4, there's only, the 3rd Amendment hasn't been incorporated. The 7th Amendment hasn't been incorporated. The first clause of the 5th Amendment hasn't been incorporated. And then the excessive bail of the 8th Amendment hasn't been incorporated. So there's 4 freedoms out of the 32 that have not been incorporated yet to the states, because the Supreme Court doesn't rule on any of these cases that they want to rule on. They can only rule on the cases that are presented to them, which is kind of crazy to me. So it's like, do we have the 3rd Amendment? Don't we have the 3rd Amendment? Well, you'd have to enforce your 3rd Amendment and then eventually work it up through the federal courts and get to the Supreme Court. Then they would rule on it. Now, I would tell you, yeah, you do have a right to the 3rd Amendment. That is what it says, and it says what it means. You're an American, right? Since you're an American, you have a right to the 3rd Amendment. You don't need the Supreme Court to endorse it when it comes to the incorporation. So you got 32 freedoms from Amendment 1 through 8. 32 freedoms from Amendment 1 through 8. And then we haven't got 4 of those freedoms. So 28 out of 32 of the freedoms from Amendments 1 through 8 have already been passed. Since 28 of the 32 freedoms have already been passed, that's over 90%. 28 of 32, can we get an exact number for that? So what is 28 divided by 32? 28 divided by 32 is actually 87.5%. Okay, so out of the Bill of Rights, Amendments 1 through 8, We've already passed 87.5%. So the trend is approaching. We're going to get all of our freedoms. We're going to get all the freedoms in the Bill of Rights. We've already got 28 of the 32 freedoms in the Bill of Rights. The trend, if you know anything about calculus, you can look at the curve, and the curve just looks like it's approaching 3. And technically speaking, it may never actually hit 3. But calculus says at the point infinity, that damn thing hits 3. So therefore, they're approaching. This is the language of limits in calculus. So what does that mean? That means that the Constitution, the incorporation process, is approaching total incorporation of the first 8 amendments. The Supreme Court is approaching total incorporation of the first 8 amendments to the U.S. Constitution. How exciting is that? How exciting is that? You have this administration right now that has problems with the Constitution. The current administration, they told him, well, you got to enforce the Constitution. He's like, why should I enforce the Constitution? Well, you took the fucking oath of office. What was the oath of the presidency? The oath of the presidency is, I do solemnly swear or affirm that I will faithfully execute the office of the President of the United States. Let's see, full text. And then they're going to protect the Constitution. The cops protect the Constitution. The military protects the Constitution. So the oath, as outlined in Article 2, Section 1, Clause 8, I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. So right now we have a presidency that's running away from the Constitution. They said, you're supposed to enforce the Constitution. He was like, well, no, not really. And then you had the habeas corpus debacle. Not only do you have Stephen Miller that's saying, we're trying to get out of this habeas corpus bullshit. So that, flies in the face of the Heck v. Humphrey decision when you have no habeas corpus. So when the presidential administration, they don't care about the Constitution. They're trying to get away from the habeas corpus, thing, that whole, you have the body, thing. There was a couple other things that he said. 9-0. The Supreme Court had ruled 9-0, saying that he has to effectuate and facilitate the return of this Abrego Garcia so they could actually finally try him to see if he is a part of, any known gang and to see about his status of illegality. Not go to ruling, right? And then I don't know when it comes to the Constitution. And then there is a habeas corpus debacle. We don't just have a right to a habeas corpus. We actually got a right to a whole bunch of rights and freedoms. We have a right to a whole bunch of rights and freedoms. And if I can pull this up quickly, then I will. I'm thinking I'm not going to be able to pull it up quickly. But essentially, read your fucking constitutions. You would think Americans who talk about the Constitution on and on and on would actually read the damn thing. Whoops. We forgot to read the damn document we all pretend we cared about. Whoopsie-daisy. Whoopsie-daisy. So, total incorporation plus 1. I think that the first 8 amendments should be incorporated plus the 9th Amendment. Why not just add one more amendment, Why just incorporate only 8 amendments to the states? Now, there's more freedoms in the very beginning of the Constitution. We have a right to be free from bills of attainder. That's in the body of the Constitution. That's outside the first 8 amendments. We have a right to contracts. We have a right to contracts. That's in the body of the Constitution. That's an important right to the Constitution. We have a right to a post office box. We have a right to a post office box. We have a right to a jury trial in all criminal cases. We have the right to habeas corpus and the freedom from ex post facto laws. We also have the right to travel between the states. Article 4, Section 2, Clause 1. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. So, whereas immunity for the public officials is nowhere in the Constitution, they do talk about immunity 2 times. And the immunities that they talk about 2 times in the Constitution is the Privileges or Immunities Clause and the Privileges and Immunities Clause. Both of those immunities are for you. The average American, the American citizen. So who's actually immune? The American citizen. You're not allowed to fuck with us. You're not allowed to fuck with our freedoms. So ordered liberty, I thought was an interesting. Let's see, rights not mentioned. Then we have freedoms past the Bill of Rights, the first 8 amendments. We got the 9th Amendment, and we have the 10th Amendment. And then here I wrote a couple that we have past the 10th Amendment. We have the right to vote, right? That comes from the women's right to vote, 19th Amendment, black man's right to vote, 15th Amendment, 18-year-olds' right to vote, 26th Amendment, freedom from poll taxes, 24th Amendment. All those imply a general, all citizens have a right to vote. And it's kind of common sense. Of course, all citizens have a right to vote. We also have freedom from slavery or involuntary servitude. So we have a right to liberty, a right to, life, liberty, property. This is just basic natural law stuff. Of course we have a right to life, liberty, and property. Of course we do. That comes from God. That's inherent. That's obvious. Just use your own rationality. We also have freedom of due process and equal protection and life and immunities and property, the right to birthright citizenship. We also have a right to alcohol. We have a right to alcohol. The 21st Amendment overturned the 18th Amendment. They tried to ban, prohibition. They tried to ban alcohol, and then they passed an amendment to undo that ban. So that's what you got to do. If you want to get rid of any of these amendments, you got to pass another amendment, or you got to have a brand new constitutional convention and just change all these laws. So we have a right to alcohol. That's incredible, right? Whoever talks about the right to alcohol. I'm an American. I have a right to drink this beer. I have a right to down this fifth of vodka. That's my God-given right as an American. We also have the right to be free from 2-term presidencies. You can't have 3 fucking terms. No, that goes against America, goes against our Constitution. We have the right to be free from 2-term presidencies. That's the 25th Amendment. We also have a right to keep from Congress from giving themselves a raise. No, Congress, you can't just give yourself a raise. If they increase the pay, they have to increase the pay for the future, but not for themselves. That's the 27th Amendment. So there's freedoms before and after the first 8 amendments to the Constitution. So when you have that damn Homeland Secretary who didn't know about habeas corpus, you think she knows about ex post facto laws? You think she knows what a bill of attainder is? What about the right to a contract and the right to a post office box? The Congress has all those powers. They have the right to build a road and an office, a post office road and office. Who is Congress constructing these post offices and roads for? We the people. We the people have the power. So we have a right to habeas corpus. We have a right to ex post facto laws. We have a right to a bill of attainder. We have a right to contract, a right to a post office box, a right to a jury trial in all criminal cases. And that just doesn't come from, the 4th or 5th or 6th Amendment. That comes from the body of the Constitution. The right to a jury trial, we got a right to a jury trial twice. It's embedded within the body of the Constitution, and it's the 4th, 5th, or 6th Amendment. So 2 times it's mentioned that we have a right to a jury trial. The right to habeas corpus, the freedom from ex post facto laws, and then the right to travel between the states is this. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. What does that mean? That means there's more freedoms that's out there. The 9th Amendment insinuates there's more freedoms out there. So, my God, this is exciting stuff. Is everybody excited about this? Being an American, we have so many goddamn rights and freedoms. It's incredible. It's so great that all Americans are on the same page. If somebody comes up and they're talking a fool or whatever, and they say, hey, you're a son of a bitch, and then they walk the fuck away. I called this older lady an asshole one time, and I got stopped by the police, and I had to talk to them for 30 minutes. My dinner got cold. It's embarrassing. I'm out there talking to them because I called an older woman who was being an asshole. Well, all Americans know that you have a right to free speech. I wasn't sitting there harassing her. I wasn't sitting there just calling her asshole all day long. I just said she was an asshole, and then I went the fuck on. So all Americans know that we have a right to speak. We have a right to religion. We have a right to peacefully assemble. right? We're all on the same page. If the U.S. Constitution isn't common law, then we don't have any fucking common law whatsoever. Why would we go to ancient England to get ourselves some common law when we don't even have the Constitution as common law here in the United States of America? 9-0 Supreme Court decision. Let them enforce. They made the ruling. Now let them enforce it, right? That's Worcester v. Georgia. They're going to do some Andrew Jackson shit. They're going to just flip off the Supreme Court and say, fuck the law. Fuck the laws. This presidency doesn't give a damn about enforcing the Constitution. Shouldn't you enforce the Constitution? I don't know. You did take the oath of office. So if you're not enforcing the Constitution and you don't know about habeas corpus and you're going to go ahead and overturn the 9-0 SCOTUS decision, 9-0. 6 of the 9 are goddamn conservatives, and then 4 of them are originalists. So this presidency is just going to tell the goddamn court to go to hell? So then who's enforcing the Constitution? And then here's another thing. The only thing that Donald's allowed to do are 2 things. The President of the United States is only allowed to do 2 things. They're allowed to do anything that an act of Congress enables them to do. If Congress passes it, the President can do it. And what's in the Constitution? The President can do an act of Congress or an act of the Constitution. He can't do anything outside of that. Thomas Jefferson, when he bought the Louisiana Purchase, he was worried about whether or not he had the constitutional authority to do so. He was buying, basically the other half of America for pennies on the dollar. And he's like, do I have the authority to do this? It's a good deal. It's a good deal. It's good for our country. But Thomas Jefferson was sitting there racking his brain over whether or not the Louisiana Purchase was actually constitutional. You think we got a goddamn commander-in-chief that's, scratching his head and just being like, wait a second. Hey, guys, I don't know if this is constitutional or not. He don't care about the Constitution. The only 2 things he's allowed to do is an act of Constitution or an act of Congress. This is fascism. This is totalitarian fascism. And so now we're all praying that he's just a good guy. Hopefully he's just a good guy. So, what does that mean? That means we got a case. We got a legal case that has standing. We have a legal case that has standing and it's ripe. It's ripe. Out of the 32 freedoms, 28 of the freedoms of the Bill of Rights have been upheld. 4 of the freedoms have not been upheld. This is a chance to get the grand jury right upheld. We actually get the 5th Amendment. Should we allow the 5th Amendment to go extinct? They said they didn't want the 2nd Amendment to go extinct. Are we going to allow the 5th Amendment to go extinct? What about the 6th Amendment, the 7th Amendment, the 8th Amendment? Are we going to allow all of our Bill of Rights to go extinct? The grand jury comes from before the Magna Carta. The grand jury's been around for a long time. It's in 48 of the 50 state constitutions today. It's part of the 5th Amendment today. In 1871, 34 of the 37 states at the time, they had grand jury provisions. Blackstone defends the grand jury. Koch defends a grand jury. These are common law authorities. And Hurtado says that you can skip over the grand jury, but you got to have a preliminary hearing. You got to have some judicial determination of probable cause. If you don't have a determination of probable cause, then that's just fucking fascist, tyrannical bullshit. That's just bullshit, tyrannical fascism. That's all you're doing. It's bullshit, tyrannical fascism. So a cop can fucking kidnap a person, and you could have a corrupt prosecutor and a judge, and then your life is fucking over, and that's just it? That's all she wrote? Because that sucks. If you have to just blindly be, fucking super obedient to any goddamn badge that says, hey, I want to put my hands on you, that makes me very nervous. That gives me a lot of anxiety. Being a lawful person, as soon as some fucking douchebag says, hey, I want to touch you. I want to touch you and put you in my car. Well, fuck. I got to obey all the laws, so all right, if you want to kidnap me, if you want to touch me and kidnap me and rape my body, go ahead. That's bullshit. So I think that you should stand strong. You should stand strong. You shouldn't just go willy-nilly with anybody. Resist? We got to come up with a different goddamn term. Because they want to say, stop resisting! It's human nature. If somebody's grabbing at you, to pull away. Somebody's yelling at you and grabbing at you and hitting you, attacking you. It's just fucking nature. It's human nature to, not only get away from that, but maybe even turn around and turn the defense into an offense. Due deference. Do I want to say due deference? You got to make sure that the damn thing is right. So let's everybody just take a breath. Everybody count to 10. Everybody take a breath and let's just count to 10. So we have a Wright case that lacked standing. You got a whole bunch of U.S. history and tradition of the grand jury, the Anglo-American jurisprudence of the laws, the state laws since 1871, the Magna Carta, Blackstone, Coke, the Assize of Clarendon. How are you going to forget about the Assize of Clarendon? King Henry II? You're just going to let King Henry II just die off like that? We got in this court. So the hierarchy of laws is on my side. Constitutional fidelity should trump practicality. The Constitution should say what it means and it should mean what it says. Now let's read 2 of the Colorado statutes, okay? Maybe I'm making all this stuff up, right? Maybe there's something in the Colorado statutes that say that you don't get a right to a grand jury indictment. Maybe. Let's just check it out real quick. And I kind of want to get to the history. I mean, I wrote all that history down, and I kind of want to keep on writing some more history because I got some more books. But we're going to take a look at Article 2, Colorado's Bill of Rights. We're going to look at Section 8 and 23. So this is Section 8 of Colorado's Bill of Rights. Prosecutions, indictment, or information. Unless otherwise provided by law, no person, not just citizen, no person, so that's anybody in Colorado, for a felony be proceeded against criminally otherwise than by indictment, except in cases arising in the land or naval forces or in the militia when actual service of time of war or public danger. In all other cases, offenses shall be prosecuted criminally by indictment or information. In all other cases. So Colorado's Constitution says no person shall, for a felony, be charged. You can't accuse a person of a felony unless you have an indictment. And an indictment, that's the language of the grand jury. You got to have an indictment. It says it right there in Colorado's Constitution. So clearly Ann E. Kelly doesn't give a damn about the Constitution. They're also not courts of record. I paid $400 for those goddamn transcripts. So the transcripts are just written transcripts. You could have an audio recording and you could also have a video recording as well. How much easier would it be instead of just allowing them bastards to, record what's going on, to actually have, it be live streamed. When it comes to the Karen Read trial, that is transparent as hell. That every goddamn witness is being live streamed to the entire world. So in a way that, all these people of the Karen Read trial, they're going to become fucking celebrities, right? So many people are watching the 2 prosecution, the defense and the prosecutor, Brennan, and then that defense guy is pretty good. He talks pretty strong. He talks a good game. But that's a problem. Because when you have audio, you could just go into a courtroom and click audio, and then you have a copy of everything that's said. If you have to pay for written transcripts that you eventually don't get, well, I'm out $400 fucking dollars, and I don't have any written transcripts. Michelle Quintana, now Zalagos, Shelly Zalagos, she stole the fucking transcripts, and they don't give a shit. They don't fucking feel bad about anything that they've ever done. They don't feel bad about stealing from you. They don't feel bad about wrecking your life. And then if this has happened to me, how many people have walked through the damn courtroom doors that they've totally fucked the fuck over? These fuckers are such criminal psychopaths, it's not even funny. Section 23, trial by jury or grand jury. So this is the other section from Colorado about the grand jury. The right of the trial by jury shall remain inviolate in criminal cases, but a jury in civil cases in all courts and in criminal cases in courts not of record may consist of less than 12 persons, as may be prescribed by law. Hereafter, a grand jury shall consist of 12 persons, any 9 of whom concurring may find an indictment, provided the General Assembly may change, regulate, abolish the grand jury system, and provided further, the right of any person to serve on any jury shall not be denied or abridged on the account of sex, and the General Assembly may provide a law for the exemption from jury service of persons or classes of persons. So here we have the grand jury exception, where you don't need 23 grand jurors and you don't need to get 12 of the 23 of the grand jurors to get an indictment. In Colorado, all you have to do is gather 12 people together, and all you need is 9. All you need to do is get 9 of the 12 of the grand jurors. So that's even more preposterous that Annie Kelly wouldn't get a preliminary hearing and she wouldn't get a grand jury indictment. It's more preposterous because the preliminary hearing, you're supposed to view it in the light favorable to the prosecution. So the preliminary hearing is already weighted on her side. And then when it comes to the grand jury, I mean, my God, that's just that's a Chuck E. Cheese. That's just an amusement park. That's a King's Island. That's just an amusement park for the prosecution. The prosecution can just show up, to show the defense, and then put all the evidence on, and, maybe the defense can testify if the prosecution asks for them to testify, but that's it. It's all closed behind closed doors, so it's all secret. The grand jury is led by the prosecution, so that means both the preliminary hearing and the grand jury is weighted towards the prosecution. It makes no fucking sense for Ann Kelly to ignore the probable cause hearing, ignore the preliminary hearing, ignore the grand jury hearing, and then just fucking go straight for, totalitarian, fascist tyranny. Nah, I just want to fuck you the fuck over. Did you want to do any of the process right? Nah, I don't want to give you any due process. Why not? I'm corrupt and malicious piece of shit. Oh, okay. Oh, okay. Well, you're a corrupt and malicious piece of shit. I'm tyrannical too, and oppressive, and criminal. So since you're tyrannical and oppressive and criminal, that's why you want to fuck me over without due process. You don't want the preliminary hearing or the grand jury indictment, and you don't want to do the Colorado Bill of Rights, and you don't want to do American Bill of Rights because you're a goddamn tyrannical piece of shit, criminal fuck. Oh, okay. Oh, I get it now. You're bad. I'm good. You're bad. I fucking get it now. Let's see here. What more do we have? Partial summary judgment. Let's see here. Probable cause hearings. People do probable cause hearings all over the place. Federalist Paper 51 says that the policy of supplying by opposite and rival interests the defect of better motives might be traced through the whole system of human affairs, private as well as public, so that the private interest of every individual may be a sentinel over public rights. So Federalist Paper 51 is saying that we want individual Americans to stand up for their rights, because when individual Americans stand up for their rights, that's not just defending their rights, that defends everybody's rights. So me standing up for the right to a grand jury isn't just defending my right to a grand jury, that's standing up for everybody in America's right to a grand jury. Those who are capable of tyranny are capable of perjury to sustain it. Any excuse serves a tyrant. U.S. v. Nixon, 1974, says this: only recently the court restated the ancient proposition of law, albeit in the context of a grand jury inquiry rather than a trial, that the public has a right to every man's evidence, except for those persons protected by a constitutional, common law, or statutory privilege. The public has a right to every man's evidence. Oh, isn't that awesome? The public has a right to every man's evidence. So if somebody wants to accuse you of a crime and you want to subpoena the eyewitnesses, then they have to bring the eyewitnesses. They have to bring the eyewitnesses. The public has a right to every man's evidence. That applied to the president. No, Nixon, you got those secret little tapes, and we want to, listen to the tapes to see if we can understand what the nature of this Watergate crime is. So since you've been the target of a subpoena, and we want to see what those tapes are, you got to give up your tapes. So you're going to try to tell me that the fucking president has to obey a damn subpoena by a court, but fucking Phil Greene doesn't have to obey a subpoena? Fucking a lay cop in Costilla County, Cruz Soto, doesn't have to, adhere to a subpoena? Somehow Robert Pickerel and Phil Greene have more power then the damn president. Nixon has to turn over his evidence, but Phil Greene and Adam Clayton and Robert Pickerel, Sam Jepsen, they don't have to turn over their evidence? Get the fuck out of here. Get the fuck out of here. Now, why would people break your Bill of Rights? Because they want to fuck you the fuck over, right? Hell, I want to actually say that I had a conflict with somebody that I think maybe a crypt, and they had said, okay, what happened? So they actually asked for the truth, and then they kind of weighed it out. And so there was like a mini trial that happened right there. So there is a person that was actually a crypt that did a court hearing and tried to find out the truth. The damn court hearing, the judicial system of the Crips was actually better than the fucking 12th Judicial District of Colorado. They actually asked for the truth. Oh, okay, so then what happened? Your dog was by the fucking river. Your dog was fucking with my fucking dogs. Your dog got caught up in my dogs. And so when I was going to the side, motherfuckers threatening me and shit. Guy wants to get mad at me about the damn shit. There's a dead cow over here. So since my dogs was playing with the neighbor's dogs, I was like, well, shit, I'll just walk to the cow over to the edge of this river where I usually go. It's a nice little, stomping grounds over there. And there's a dead cow, so you can kind of pick at the bones and shit. I'll just let the neighbor's dog go along with my dogs as I'm walking along the river. So, ultimately, I don't know if he showed mercy or just heard me out, and then I'm just being so goddamn Mr. Roger-ish. I'm just like, oh, you just want to know about my life? Well, okay, well, I was going to the river, and then, my dogs jump out. Your fucking dog was outside, so since your dog was outside, my fucking dogs jump out. So because you don't tie your fucking dog up because your dog was out, my dogs are jumping out. Now I gotta chase the fucking dog. So I could have got pissed off. I could have got angry, but instead I'm just like, well, I was at the river, your dog was there, I was there. So in some respect, the fucking had a goddamn hearing that asked about the truth. But the goddamn Costilla County doesn't care about the truth. 12th Judicial District don't care about the truth. You had that guy that killed, there was a Saguache deputy, they killed actually a couple people. Saguache had killed like 2 people with a guy had a shotgun, and then there was a guy that had that metal pipe that was attacking him. That guy didn't even get charged. So when they don't even charge a police officer who murdered a person, say it was justified, but put it in front of a jury. I want to hear 12 of my peers say that what had happened was A-okay. But when the prosecutors don't even put a police officer who kills another person up for a felony charge. So basically, if you know the prosecution, if you're friends with the prosecution, the politics of the damn thing, you don't even get charged. Why wouldn't they charge a police officer? Because they know it's a rocket docket fucking slaughterhouse. They know that if you put the damn person through the wash, it's not to find out the truth. It's not to exonerate anybody. It's not to put a stamp of innocence on anybody. That's not the reason why we're putting you through the wash. We're putting you through the wash because you didn't wear your fucking seatbelt. And since you didn't wear your fucking seatbelt, well, we're going to charge you with a crime. We're going to look down on you and treat you like a piece of shit. And then we're going to get some money out of you. And then we're going to say the system works. You weren't wearing your seatbelt, and we fucked you the fuck over. I didn't hurt anybody. That motherfucking Saguache deputy just killed that fucking dude. Well, he didn't have probable cause. There's no probable cause of a crime. There's a dead body. There's a dead body. It's possible. It's probable that he committed a crime. It's probable that a felony has been committed. They don't even put police officers through the game. They don't even give them a little charge. Not a disorderly conduct, not a seatbelt violation, not a breach of the peace, not even a tiny little charge. So, cop murders a person, DA thinks it's just, well then hell, wipe your hands, just walk on as if that person's life didn't mean shit. Just sick of the double standards. I've talked about this for a while. I still got so much more. I'm talking about Dobbs. I'm talking about how Dobbs had pointed out that there is this historical analysis. When Ruth Bader Ginsburg and Tyson Timbs v. Indiana, she traced the freedom from excessive fines of the 8th Amendment back to the Magna Carta, to Blackstone's commentaries, and then 35 of the 37 state constitutions in effect at the ratification of the 4th Amendment also protected freedom from excessive fines. I mean, isn't that exciting stuff? Am I the only one that's excited about America? A similar inquiry was undertaken in McDonald, which held that the 14th Amendment protects the right to keep and bear arms. The lead opinion surveyed the origins of the Second Amendment, the debates in Congress about the adoption of the 14th Amendment. The state constitutions in effect when that amendment was ratified. At least 22 of the 37 states protected the right to keep and bear arms. When that amendment, the 14th Amendment, was ratified. That's interesting how they worded that. So that means in 1871, 22 state constitutions protected the right to bear arms, but 34 states defended the right to a grand jury. So there is the right to a grand jury was more legally protected by the state constitutions than the right to bear arms. And federal laws enacted during the same period. The only way to ensure restraint in the delicate enterprise of judicially creating freedoms is continual insistence upon respect for the teachings of history, solid recognition of the basic values that underlie our society, and wise appreciation of the great roles of the doctrines of federalism and separation of powers. Griswold v. Connecticut, 1965. Harlan J. concurring in judgment. Footnote 12 of McDonald. We'll talk about the 12th footnote of McDonald in a later video. You want to hear about the 12th footnote in McDonald? Oh, shit.